It's live.
Welcome to today's program titled The Future of Arbitration, Part 1, Analyzing Federal Legislation Precluding Arbitration of Sexual Harassment Claims. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of this webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our moderator for today's program. Noah, please go ahead.
Noah, you're on mute.
Good morning and good afternoon, everybody. This is Noah Finkel. We are here today for the first of 3 arbitration webinars that we'll be putting on over the next couple of weeks, and thank you very much for joining us today. I am joined by 2 of my colleagues. David Baffa is a partner in our Chicago office. I've practiced with David for, gosh, I think 27 years now. Because I'm in the Chicago office as well, and while my focus is on the litigation of wage hour disputes, David's focus is on making sure they never happen in the first place. He even comments that one of his business goals is to put me out of business. We're also joined today by Molly Mooney, who is an associate at our Boston office. She, like myself, is in the wage hour litigation practice group at Seyfarth, and she has really put a lot of focus on doing a lot of writing for us in the arbitration space, which we've really appreciated. What we're going to do first is talk about why we have arbitration agreements. We have, excuse me, I'm having a little bit of technical difficulty getting over to our next slide, but what we want to start with is a participant poll. And the idea here is you can only pick one of these reasons. What's the main or primary reason why your company has an arbitration program? What we've seen is that a lot of them are doing them for different reasons. Some is to avoid mass actions. Some is because they don't like juries and think that they may get a very bad, out-of-control verdict because of one. Some think these are more private, more confidential. Others look at it from a cost perspective and think that, arbitration with often its more simplified rules of discovery and other processes just cost less than your typical federal or state court lawsuit. And of course, some don't have an arbitration program. So Paul, if you could now give people the poll, and then we can spend some time going over it. Thank you. So please check one and submit your answer, and we'll see what we get. And I should note that, of course, your answers on this are anonymous.
I answered. Am I allowed to answer?
You can, yes. But you got your chance, David. All right. So we now have used up our minute, and the poll has ended. Paul, where do we see the results? Do we have those? No.
I can read them off to you if you want.
Oh, yes, please do.
All right, so avoid class and collective action 38, no jury 17, maintain confidentiality 11, minimize costs in cycle 13, no arbitration program 27, and no answer 47.
Great, thank you very much. And I think those are probably along the lines of what we were kind of expecting. It does seem that avoiding class and collective actions, which of course one can do with a class waiver in their arbitration agreement, is the most popular. And you can that's not much of a surprise. I'm kind of surprised that minimizing cost didn't get more play. But you know, we'll circle back to these as we're talking. Now what I want to do is kind of talk about why are we gathered here today? What's happened? And the reality is, for the first time in a long time, we have a federal law on arbitration of employment disputes. And Molly is going to explain that to all of us.
Great. Thanks so much, Noah. And thank you everyone for joining us. So before we sort of talk about how we got where we are today, I'm going to give a little bit of background about what HR 4445 is and what it does. So HR 4445 was passed by both the House and the Senate in the second week of February. And now the next step is for President Biden to sign the bill into law, which has not yet happened. But we do know that the Biden administration supports the bill because it issued a statement of administration policy. And you can see we've included a little snippet from that statement on the slide. But ultimately, what the statement says is that the administration is committed to eliminating sexual harassment and assault, and that it wants to work with Congress to guide this bill through the legislative process. So we can expect that this bill is going to become law. And interestingly, just a side note, at the end of the Statement of Administration Policy, it states that the administration, quote, looks forward to working with Congress on broader legislation that addresses these issues, as well as other forced arbitration matters, including arbitration of claims regarding discrimination on the basis of race, wage theft, and unfair labor practices. And we're going to touch on that more later today, but clearly an expansion of this is on the radar of the Biden administration and possibly indicative of more to come on this. So what does HR 4445 actually do? Well, it permits someone alleging sexual harassment or sexual abuse to invalidate an arbitration agreement or a class and collective action waiver that would require them to arbitrate their sexual harassment or abuse claim. So the bill defines pre-dispute arbitration agreements very broadly, so that it includes any agreement to arbitrate a dispute that had not yet arisen at the time of the making of the agreement. Now, from our interpretation, that seems to include any arbitration agreement. The definition does not refer back to earlier provisions of the FAA, and it has its own standalone definition. So reading that, it probably covers all arbitration agreements, whether they're covered by the FAA or not. It's unclear. That's an issue that we're considering and thinking about, and likely will have more information on as this goes into effect and ultimately is litigated. So the bill also defines both sexual harassment and assault rather broadly. It includes any acts that would constitute harassment or sexual assault under federal, tribal, or state law. And importantly, the bill also provides that any questions relating to its applicability or to any of the provisions will be resolved by a federal court and not an arbitrator, even if an arbitration agreement references that certain disputes should be resolved by the arbitrator. So it'll always be the case that our federal court will be interpreting whether or not this bill applies. Now, the bill was described by Senator Schumer as, quote, one of the most significant changes to employment law in years. And you can see why. It's very broad, and it's essentially carved out sexual harassment and assault claims from any mandatory arbitration. But importantly, individuals can still elect to arbitrate their sexual harassment or sexual assault claims, and that's important. One of the senators or representatives sponsoring the bill noted that some survivors of this type of misconduct might not want to publicly litigate their claims. So it's still an option to arbitrate if that's what the individual wants to do. And now we'll turn it over to Dave to talk a little bit more about the background of how we got here.
Yeah, thanks, Molly. Before we're going to take a little deeper dive into some of the gray areas associated with this new law. But before we do that, just a kind of a brief history lesson here in terms of how we got to this place. Although the law is new, the concept really isn't. Back in 2009, former Senator Al Franken of Saturday Night Live fame, he was the senator in Minnesota, really pursued what's referred to this day as the Franken Amendment, and it really was this same concept that the design of it was, originally his design was in general to carve out sexual harassment and sexual assault claims from mandatory arbitration programs, and ultimately it settled on what really became just an appropriations law, which affects only Department of Defense contractors who are interested in doing business with the federal government in contracts in excess of $1 million. Those DoD contractors can't take advantage of those kind of contracts if they require arbitration of sexual harassment claims. And interestingly, when it went into effect, it became broader than just sexual harassment claims and really covers all of Title VII. And we're going to come back to that point a couple of times here as we talk about this today. But the net takeaway is that although this is new for some of our clients, companies that have been Department of Defense contractors have been dealing with this carve out really since February 2010. Since that time, more recently, there's been a number of states that arose mostly out of the Me Too movement starting in around 2018. Quite a number of states sort of got on this same theme and passed legislation designed to prevent the mandatory arbitration of again, sexual harassment claims was always the kind of going in position and the main sort of impetus for passing these laws. But many times the actual prohibition sort of was stretched to include any claims of discrimination, harassment, or retaliation. So actually the states here on the screen that are colored in orange font maintain a prohibition that is broader than just sexual harassment and sexual assault and includes other types of discrimination claims. So that includes California, New Jersey, Washington, New York, and then Maryland and Vermont have laws that prohibit sexual harassment arbitration that's pre-dispute. Other states, Illinois, flirted with this, but ultimately backed off in favor of more procedural protections around arbitration. And what's interesting about these states is they didn't really slow the train very much because all of these laws really are preempted by the Federal Arbitration Act to the extent the Federal Arbitration Act can be applied to the agreement, which is the case for most employers, with a few exceptions. But if you're in interstate commerce, and unless you're talking about transportation workers, you're generally the Federal Arbitration Act controls your agreement. And all these state laws are preempted. They're still preempted. It's just that now federal law, mirrors, at least portions of the requirements in these states. So that's pretty much what we've been dealing with up to now. And then I think we're going to get into some of the nitty gritty on the current new law.
Yeah, and Dave, I'll take that over, and here's where I get to play law professor for a little bit. So I have a hypothetical question for the two of you. Let's say a company has a holiday party in December. Still got to go forward despite Omicron. And during it, an employee feels like they have been sexually harassed. So, this is before HR 4445 passed. That's when the conduct occurred. A few months pass. that employee does not file a claim, perhaps she alerts her company of her claim, but does not file anything formal in court or otherwise. And then, let's say next week, President Biden signs the bill, it goes into effect. And then the employee files a lawsuit alleging that she's been sexually harassed. Can her claim be put into arbitration, or does she have to be given the option of going in court?
I'll take this one. Thanks, Noah. I think that's a really good question, and it's something that we've all been discussing here at Seyfarth internally, and we know that other firms are grappling with this issue as well. We actually had a participant submit a question about whether HR 4445 is retroactive. So this it's all the same question. So essentially, what this comes down to is how you interpret the language of the bill. So you can see on the slide, we've included the language that it applies to any dispute or claim that arises or accrues on or after the date of enactment. Okay, so what does that mean? Well, there's really two results here, right? So result one is that the claim can be arbitrated because the conduct occurred prior to enactment of the bill. For that to be the case in this situation, you would have to read arises or accrues as meaning when the conduct giving rise to the claim actually occurred. So, which in this case was December at the holiday party prior to enactment of the bill. Therefore, HR 4445 doesn't apply, and then the claims can be arbitrated. The other result is that the claim can't be arbitrated because it was brought after enactment of the bill. So for this to be the case, the argument is that while the conduct occurred in December, a claim did not actually arise or accrue until the individual chose to bring it, which would be after HR 4445 was enacted, and therefore it would apply. So the claim for harassment in December 2021 accrued before enactment of the bill, but then it wasn't brought until after. So it really depends on how you interpret the language. And the language in this provision is unfortunately unclear. So we've seen that some firms have taken the position that this bill only applies to claims arising from conduct after enactment. So in our situation, the sexual harassment claims from the holiday party in December would be arbitrated. But we think it's not as clear cut as that. And again, this is another issue that will be litigated and we'll see how it plays out. But Representative Bustos, who is the primary sponsor for this bill, was quoted as saying that the bill would apply to any new claims, regardless of when the bad behavior occurred, and barring any state or local law that might limit when a claim is brought. So that's obviously not the final word on this, but it is indicative of at least some legislative intent.
Okay, so now let me ask you another question, put a twist on this. Let's fast forward to after the bill's already in effect, and another employee says they were sexually harassed at the let's say the company's 2022 holiday party, and they claim not only were they sexually harassed at that time, but that they also their employment was terminated after they complained about that, and in fact before then. They had been discriminated against on the basis of their sex because they weren't paid as much as similarly situated men, and the employee did not get a promotion that she wanted, and then threw in a fourth claim and said, you know what, come to think of it, I wasn't paid for all my time worked while I was employed with the company, and in fact, I'd like that part of my complaint to be certified as a collective action under the FLSA. What happens then? What goes into arbitration? What doesn't?
Well, I guess it's my turn. This is the second point of curiosity with respect to this new law. In addition to that language on the prior slide about dispute or claim that arises or accrues, the statute curiously seemingly intentionally uses the word case here in orange to make the point that, and it has caused a number of practitioners to be concerned that, for example, a claimant can sort of throw in a sexual harassment claim to defeat, for example, an attempt to mandate arbitration of a wage hour dispute. Now, in your hypothetical, I think there were, 2 or 3 claims that we would more traditionally think of as related. I think it's undisputed that, and I think the intention here is to say, look, if somebody who is a victim of sexual harassment also is sort of relatedly denied a promotion or experiences a job loss, we're not going to let you carve that up and, only litigate in court the sexual harassment claim and try to cleave off the sort of clearly related claims around promotion or termination that sort of arose from those facts. I think when you start to bridge into, when I also didn't get paid for my time or sort of wage hour issues, our thinking, our hope, our expectation is that you'd have a much stronger argument to be able to carve the wage hour aspects of the case out and compel them to arbitration if you wish. There may be strategic reasons in a single plaintiff context where that wouldn't make sense. We don't usually expect to find sexual harassment class actions, so it's hard for me to understand how a wage hour collective action could be so intertwined with a sexual harassment class action allegation that, I think there's more kind of hand-wringing or worry about this than is probably practically a real matter of concern. I mean, I think for the most part, as an employer, if you want to compel unrelated claims to arbitration, we think you're still going to be able to do that with this language.
So I'm a little bit of trouble getting over the next slide. I'm sorry. So my questions are not done. Let's say, for example, you now have an arbitration agreement that does contain or at least could be interpreted as containing a requirement that any sexual assault or sexual harassment claim be arbitrated. What do you do? Should companies be rewriting their arbitration agreements now if they explicitly have if they explicitly cover harassment, or if perhaps they just say all claims related to your employment are subject to arbitration?
Yeah, so not surprising that we're getting a lot of questions about this, and there's an important point on this slide that some people have asked about as well. I've noticed in the chat here. I think it's important to distinguish and to think about sort of arbitration programs differently than executive agreements that might contain an arbitration provision. Unfortunately, those concepts, I think, have been kind of blurred and intertwined to some degree. And, in our experience, when you're talking about an arbitration program that all employees would be a participant in, there typically are all kinds of procedural workings that make the proceeding really like just a substitute for the courtroom. Now, yes, there's no jury trial, but generally there's the full complement of remedies, discovery, statute of limitations. It's really just a substitution of the forum. And oftentimes there is not this sort of non-disparagement confidentiality component to those programs. People need to be able to put on their case in the same way that they would be able to if they went to court. And there are National Labor Relations Act and other reasons why you can't sort of, gag or put a full kind of confidentiality cloak around those programs. Now, by contrast, executive employment agreements, sometimes, for a high-level executive, it may be in their mutual interest to keep things more confidential. Usually they're lawyered up and negotiating the terms of those agreements. But some of the more sort of salacious, events that have occurred and about which movies have been written of late, really arise out of those executive employment agreement sexual harassment situations, not really out of arbitration programs. And so in the context of what to do, I think the first thing you have to take stock of is what kind of agreement are we talking about? You know, it seems awkward to go to all your executives and say, hey, good news, you know, you can take your sexual harassment claims to court now. You know, I mean, or I want to amend the agreement to make that more clear. That feels awkward. And the law does not require you to amend your existing provisions or programs. It makes them unenforceable with respect to sexual harassment claims, but it does not require you to amend them. Now, having said that, whether it's a program or agreement, I would look for a few things. I would, and you've alluded to this, Noah, in your question, I would look to see whether, you know, does the agreement or provision now explicitly state that sexual harassment or assault claims must be arbitrated? Most agreements, a lot of agreements that we write use broader language than that, talk about disputes arising out of the working relationship. They don't get into a laundry list of included claims oftentimes. I would also look at whether or not the agreement or provision includes a carve out that says claims that may not be arbitrated as a matter of law are excluded from scope. A lot of agreements will do that. I would also look at severability language, whether there's, if any provision is found to be invalid or unenforceable, does it affect the rest of the agreement? Most agreements have that language. And then, of course, you have to think about optics and your workforce. And, you know, this is an important issue for a lot of people, and you have to think about how it will land with your workforce. And I think that's what gets you to the question of whether you want to, I would certainly err on the side of making the carve out more clear going forward for new agreements, new hires. I'd be reluctant to go back and redo all the old agreements unless I saw a lot of kind of deficiencies in the current language along the lines of what I described. You know, if it seemed misleading and it was, it felt like something that needed to be addressed, you could potentially do it through a memorandum. You could potentially do it through an amendment to the old agreements. But I'd probably seek to try to avoid that. And you don't have to do it legally. You just won't be able to enforce.
All right. That's kind of a good segue, I think, into our next slide about, you know, in general, what are the pros and cons of an arbitration agreement? And, you know, and now that we have this law that restricts to what kind of claims they can apply, is it still worth having them?
Yeah, so thanks, Noah. So as Dave was sort of talking about, as you're thinking about what now, what do you do if you have have an arbitration program, if you have arbitration provisions, it makes sense to sort of weigh the pros and cons of whether arbitration is right for your company, your organization. So obviously there are a lot of pros and cons on this issue, and we've highlighted some of them. I'm going to go through some of the cons. So we've already sort of talked about the first one, and that's the uncertainty of how cases involving multiple claims are going to be handled in light of HR 4445. So you could end up with cases with multiple claims on two parallel tracks, some in litigation in court and some in arbitration. And again, that might not be a con in some circumstances, but it also could be a con if you don't want to be juggling multiple different litigations. So that's one issue. Ultimately, even with an arbitration program, employers will still have to deal with agency charges. So for example, employees can still file charges of harassment or discrimination with the EEOC. They can't then file those claims in court. Now they can for sexual harassment, but they can still file those charges. That's always going to be the case. And then in terms of arbitration itself, sometimes arbitrators can be unpredictable. So you might have an outcome that you weren't expecting, that you weren't prepared for, and ultimately that's going to happen whether you're in arbitration or litigation. But the one thing that makes arbitration a little bit different is that your appeal options are very limited. It's very difficult to overturn an arbitration award, and they'll only be overturned in limited circumstances. So you might be left with an unfavorable result. Although arbitration awards have limited precedential effect, so it might not be a huge issue, but it is something to consider. So there's also costs involved in arbitration that you don't see in court. So there's often a fee up front, and then you have to pay for arbitrators' fees. And oftentimes, depending on how your arbitration plan is structured, sometimes employers have to front the majority of those fees. So that is something to consider. And Dave's going to talk about the pros, and maybe the fees and cost issue is a wash, but it's just something to be aware of, that there are those upfront fees and the fees for the arbitrator. And on the topic of fees and costs, when you have an arbitration program, you're always going to get employees filing claims in court that should be arbitrated. So when an employee does that, it then necessitates you filing a motion to compel arbitration if that's the route that you want to go. So there will be some attorney's fees there involved in compelling arbitration of claims that should properly be arbitrated. You might also run into some issues in states if you refuse to hire an applicant who declines to sign a mandatory agreement. So that's just something to be aware of. And if that's an issue that you have, you should submit a question about that. We'd be happy to talk about that one further. And then one other point here is, we in employment litigation tend to rely pretty heavily on summary judgment, and that's not always guaranteed in arbitration. In fact, it's probably not the norm. We do push for it in a lot of cases, and those efforts can be successful. So it is an option, but depending on your arbitrator, they may not go for it. So it's a risk that you might not be able to move for summary judgment. And then last thing that I want to talk about here is just employee perception. So this kind of plays into everything we're talking about today. With events, recent events, Me Too, there is this perception that arbitration is unfair. We don't agree with that perception, but it's certainly out there. And maybe the inability now to arbitrate sexual harassment and sexual assault claims will sort of turn the tide on that, because those claims will be litigated in court, and now arbitration is just going to be of those routine employment issues. But we don't know. Ultimately, arbitration certainly has its critics, and it may not be a welcome addition to all workplaces. So ultimately, it comes down to your organization's culture and whether you think it would fit in with your culture.
Yeah, so this is, these are really, a lot of employers have struggled with these questions. A note in the poll results that about 18% of you, 27 respondents, don't even have an arbitration program and have probably been wrestling with some of these questions. Most of you that answered answered the way I answered, which is the reason that I would do a program like this is really for the purpose of avoiding wage and hour collective actions. It's that class waiver component that really, I think, tips the balance in the pros and cons, over to the pro side. The other advantages of arbitration, of course, include avoidance of a jury trial for individual disputes. There is generally, even though I mentioned in an arbitration program, there are limitations into how much confidentiality you can expect. It is at least a non-public proceeding. There's not typically a reporter or a news feed sort of beat writer, sitting on the courthouse steps in quite the same way in an arbitration proceeding. So you have a little bit more, confidence that things will stay quiet. There is the possibility in arbitration to put some reasonable limits in place on discovery. You don't have to do that, but within reason, recognizing that arbitration is supposed to be a more streamlined procedure with a faster cycle time. There are ways that you can put reasonable limits in place, and an arbitrator can always order more discovery if necessary. Um, you know, when done well, an arbitration program, um, the one thing about this law that I think is a little bit of a shame is that it feeds this perception that arbitration is an unfair procedure out of the box, and it really doesn't have to be that way. Senator Ernst had proposed legislation that was designed to try to make arbitration more fair, and it included provisions that we always include in our agreements that we draft here at the firm, that it really is more about just the substitution of forum. Yes, it is the avoidance of a jury. I understand that that's a big deal for a lot of people, but other than that, it's essentially like a bench trial, but in an arbitration proceeding is the idea or the design usually for these programs. There's usually a shorter cycle time. You get through a case a lot faster, and there's an opportunity with the dispute resolution to actually work things out with the employee before you pay for the arbitration to proceed. We also find in general that at a certain scale, there's usually lower total fees through hearing versus certainly there's lower fees to go through an arbitration hearing than there is to go through a trial. We also find that if you collect enough cases or disputes through the system, we had a question that came through today about, are arbitrations more cost effective than litigating an employment claim in court? And the answer is it depends. And it largely depends on volume. Because you have to pay for the arbitrator and as an employer, you're paying for the arbitrator, you're paying most of the costs. If you just get 1 or 2 employment disputes a year, arbitration may end up being more expensive for you net with fees and everything else. But we find that after about 10 to 12 disputes, if you've got that kind of volume or higher, that overall we find that the expense load tends to come down with an arbitration program. A lot of times that is because of the lack of settlement leverage, because there's no sort of jury trial threat hanging over. But that's generally our experience in terms of how the costs compare. So I think,
I believe this is,
yeah,
you're still going.
I think, just to sort of tee this up a little bit further, for a variety of reasons, we wanted to talk about something that I know Noah and I have been pushing for a lot of years here, which is that in our view, the program that may make the most sense for most employers is just to consider a wage hour only arbitration program. Most of the class action, collective action risk that is out there comes from the wage hour space. Is it possible? Does it happen where you get private plaintiff-led, race class actions? Of course. Usually, though, discrimination class actions are brought by the EEOC, or it's something that's sort of government-led. You don't see a ton of private-led discrimination cases, at least not as compared to wage hour collective actions. And so one program that we like quite a bit is a program where you find that balance. You completely sidestep the kind of political, cultural, legislative headwinds here and legitimate concerns about this sense of having to arbitrate sexual harassment and other claims. One of the problems that I think employers will face now, and it's the same thing that many states faced when they were considering similar legislation, is how do you justify carving out sexual harassment claims and not carving out racial harassment claims from your program? I think that's that's a bit of a tightrope to walk. And so, moving to a program where you just arbitrate wage hour only avoids all those concerns, and I think makes a ton of logistical sense. The truth is, when an individual employee feels shorted on their pay, or they've they've been gypped out of overtime or not paid their final pay at termination, you have an opportunity to actually sit down and work it out with a dispute resolution process. And if you can't agree or don't agree, to arbitrate it. And by contrast, when employees bring wage hour collective actions, they're often making cents on the dollar. And the only folks that are really profiting from that activity are the plaintiff's lawyers. So it just makes a lot of kind of business sense, legal sense, procedural sense, in our view, to use these arbitration programs to stay out of wage hour collective actions. So that's, those are what we like to think about. There are a couple downsides we should touch on, and if only because it tees up the next topics. But, the two downsides, again, remember, is it's not going to help you against DOL lawsuits and there's still PAGA claims out there. Our next webinar in part 2 is going to talk about that. And there's a growing risk of, mass arbitration, which is going to be part 3 of our webinar series, where we talk about some techniques to avoid the possibility of getting caught up in one of these mass arbitration schemes. I think we've got 5 minutes, Noah, right? For a few questions.
We do. Yeah, we want to try to cover a couple of questions that people have. We probably won't be able to get to all of them, but we, and some of them we know were answered during the course of our presentation today. But a few I don't think were, and we wanted to get to a couple of them, especially the ones that sent them in ahead of time. One question we got was, how does this affect gig workers? And the answer there, which I'll give, is that it really depends. I mean, it will certainly mean that gig workers cannot be compelled to arbitrate a sexual harassment or sexual assault claim. But even there actually is a little nuance. There's a little debate about whether this bill is something that just amends the Federal Arbitration Act so that the Federal Arbitration Act can't be used by employers to mandate the arbitration of sexual harassment claims, or if it's just a standalone, all by itself ban on mandatory arbitration of sexual harassment claims. And the reason that matters is because in the gig economy, a lot of workers are exempted from the Federal Arbitration Act because they're engaged in interstate commerce. This would be your, for example, delivery driver, last mile delivery drivers have been held by one court to be exempt, and it has been contended that rideshare drivers are exempted as well, though most courts have rejected that claim. And if a employee is exempted from the FAA, they still may have their claim compelled to arbitration under a state arbitration act, even though not the Federal Arbitration Act. And then the twist here is, if that's the case, does HR 4445 ban mandatory arbitration of a sexual harassment claim? We don't know the answer to that yet because it is a bit unclear. It seems that this is probably something that is standalone, but we're not sure how courts are going to interpret that. Another question that we got is, what does this do for collective bargaining agreement? If a collective bargaining agreement has an arbitration provision, what does this do? And I can tell you that those are not, this is another unclear question. Those are not excluded from the reach of HR 4445. There's not any exemption for arbitration agreements that are arrived at pursuant to a CBA, but what will be interesting is how courts interpret such a provision in a collectively bargained agreement. Is that mandatory arbitration, or is it permissive? In a sense where hey, the union members wanted this. So how will that get interpreted? I tend to think that it will still be regarded as employer compelled, in a sense that it's the employer and the union that have agreed to required arbitration. They can't bar they can't mandate that an individual no longer get access to courts and have to go through arbitration instead. But that's unclear. Let me see if I think we're actually out of time. And what I want to make sure is that before we let you go, that we give the CLE code, which is SS, as in Seyfarth Shaw, 7362. Again, that is SS 7362. And I believe that concludes our program for today. Thank you very much.